Thank you very much. I'd like to begin by thanking the previous presenters and touch on the issues raised in both their presentations in terms of the kinds of challenges being experienced by middle-income countries. And why are middle-income countries important at this point in the epidemic and going forward? We know from UNAIDS and from other estimates that middle-income countries are and will continue to be in the future home to the largest cohort of people living with HIV. So issues around the price of medicines for people living with HIV and other health conditions more broadly will continue to be of great relevance, particularly in middle-income countries. Yet, in middle-income countries, economic classification, such as the World Bank classification, which Lena referred to, deprives these countries of the benefits which are afforded to lower-income countries in terms of improving access to treatment. So in building sustainable treatment programs, middle-income countries need to really use every possible opportunity and avenue available to them to ensure affordable access to medicines. It's a critical part of the right to health, the right to life, a fundamental human right to everyone, regardless of what level of income is accorded as a category to the country in which they live. So one of these avenues is the subject of my presentation today. It's about using competition law to promote access to health technologies. Many of you will be aware the Global Commission on HIV and the Law gave a range of recommendations on issues relating to HIV and the law. They talked about bad laws which are hindering effective HIV/AIDS responses and good laws that need to be replicated, scaled up, and used much more effectively. Intellectual property and treatment access was one of the areas that the Commission traversed, researched, and made some recommendations on. One of the recommendations was that countries must proactively use all areas of law and policy, such as competition law, price control policy, and procurement law, to help increase access to pharmaceutical products. Competition law has been used by some countries to ensure healthy competition and reduce prices. Despite its potential, it's one of the least discussed flexibilities in the TRIPS agreement. For example, when a compulsory license is used to remedy an anti-competitive abuse of an intellectual property right, the TRIPS agreement provides countries with a wide berth to determine how that compulsory license should be used and applied. So there's a great untapped potential here, or an opportunity for low and middle-income countries to incorporate and use competition law to sustain national treatment programs. And this is exactly the need and the argument that was highlighted by the Global Commission on HIV and the law. So in the last year or so, UNDP has convened a group of experts to develop guidance for countries on competition law. And based on our mandate of helping countries to strengthen legal environments for more effective HIV responses and safeguarding treatment access, we brought together this group of experts to develop this guidance. The guidance covers competition law as it is situated under international law. It highlights and describes what anti-competitive behaviors and remedies for these anti-competitive behaviors, issues of market dominance and how to define that, and some of the challenges facing developing countries. So in addition to covering the contours of the problems and the kinds of tools that are available, it includes model provisions for principles that need to be included in national legislation around competition law, and provides some very good country case study examples so countries can be inspired and motivated to use these. So a sample of anti-competitive practices in the pharmaceutical sector. One of the most common ones that we see are called patent thickets, or where you have patents pretty much for for the same product, really, essentially. So there was a report in 2009 from the European Union of the Pharmaceutical Sector Inquiry Report, which showed that there was more than 1,300 patents and applications were found for a single medicine in some cases. So basically, unnecessary patent applications because it wasn't for anything new, but it was patents for similar, for the same product. And several applications happened just as the patent term was coming to an end, so it was just a way of extending the patent unnecessarily and preventing access. The same EU report found spurious litigation successfully delaying the entry of generics into the market by at least 6 months on average. And this is where companies may pursue litigation even where there aren't reasonable grounds to prevent the delay into the market of a potential competitor, and then a competitor that might actually drive down prices of a medicine. Restrictive practices and licensing agreements, that's another anti-competitive practice, come in many forms. For example, exclusive grant back clauses or pay for delay deals. Other examples of anti-competitive practices are abuse of dominant power, market collusion, or merging to acquire generic competitors into large multinational corporations. And this is something that we're seeing, it's a worrying trend that we're seeing in India, Brazil, Egypt, and other countries. So what are the advantages and some of the challenges of using competition law to increase access to treatment? One of the great advantages is that it's less multilateral regulation with competition policy. You have more flexibility in TRIPS than in patent laws. And the great thing is that you don't have to wait or rely solely on government intervention. You can, competition law can be used by and has been used by civil society, patients groups, NGOs, and generic companies. But there are some requirements and challenges. One of the big issues is that it's just not been talked about a lot. In the access to treatment movement, we've talked a lot about patents, we've talked about compulsory licenses, voluntary licenses. We haven't talked much about the use of competition law as a flexibility that can actually help us to improve access. It can require complex enabling legislation and regulations. And by and large, what we see from our perspective at UNDP is that at the national level, there hasn't been sufficient resource put into building capacity and investing in competition commissions or competition legislation, and this is something that we're working to remedy. National level policy coherence, you can often have disconnect between competition law and other laws, and actually developing countries are more susceptible to market concentration. This also poses a challenge. So some examples, case studies to kind of give us a real life feel for how competition law can be used. So this is a great example. I'm going to basically use examples from South Africa. They're very powerful, but the guidance, the UNDP guidance, which I encourage you to look up on our website, has examples from a number of other countries. So civil society organizations have actively used competition law in South Africa and used the competition framework to address concerns of anti-competitive behavior in the medicine sectors, particularly on issues of HIV. Hazel Tao is a landmark case arising from a complaint in 2002 where Hazel Tao, the Treatment Action Campaign, and others filed a case on first-line ARVs, adivudine and lamivudine. In this case, prices from the originator company were 3 to 10 times higher than the least expensive generic version. Previous requests from CIPLA, from a generic company, and MSF for licenses to acquire the medicine and make it more affordable were refused. This case was referred to the Competition Tribunal in South Africa for ruling, and both the pharmaceutical companies, GSK and BI, settled out of court by agreeing to new voluntary licenses, which brought down the royalties from 30% to 5%. So we saw a dramatic decrease in the cost using a complaint at the Competition Tribunal. In 2005, competition law again was used by TAC against BMS for treatment for cryptococcal meningitis, which resulted in a 90% price reduction. 2007, my apologies to any colleagues from TAC for the typo, it's Treatment Action Campaign and the AIDS Law Project, and again this was for excessive pricing of efavirenz, and again just the mere pressure of the case meant that we had royalty-free licenses granted to 6 South African generic manufacturers. So the conclusion basically is that access to health technologies is a fundamental human right. Competition helps to drive down prices. This is the story of treatment access in the HIV field. Yet the competition law remains an underutilized public health TRIPS flexibility. Cut and paste models from developed countries into developing countries, which is what's been happening, is really not recommended in terms of competition law. We need to have good models, good provisions in the competition law. We need to have policy coherence between competition law, patent law, drug regulatory provisions, and procurement regulations in order to make sure that we have a competition framework that's very robust. And competition law should be an important part of the toolkit used by countries to ensure sustainable financing for treatment programs and increase access to treatment. Thank you.